Well, good morning and welcome to the Great Transitions Senior Living Seminar Series. Today we're going to be tackling the topic of getting your legal affairs in order. We're excited to have you here with us. Great Transitions was founded in 2013 and we've been doing seminars in the Winter Park and Orlando area for many years now. We are super excited to start our 2025 season. Great Transitions is a system for educating and working with seniors as their lifestyle and housing needs change. Sometimes if you're preparing for a move, it could be 12 to 18 months, maybe 2 or 3 years. We had a move that happened recently that was 2 weeks. So that was due to a circumstance that had expedited the process. So whatever your needs are, whether you're looking long-term, short-term, or somewhere in between, we are all here to be of service to you and guide you through the entire process. We genuinely believe that helping guiding seniors is an honor and a privilege for us, and we look forward to speaking and working with you today and in the months ahead. Our objective here today is to educate seniors on legal matters, financial matters, housing matters, medical matters, other general topics of importance. This is a purely educational opportunity, a sales-free zone. The educational partners that are here in the room with us today that help sponsor this event each month, they're here because they too have a genuine heart for serving seniors and for empowering you to make the decisions that you need to make that are best for you. We do ask you to keep in mind a couple of things. Who's going to be tasked with making decisions for you when you're no longer able to do so? And will you agree with the decisions that they make? And finally, have you shared that plan with your trusted advisors or loved ones? And we're going to talk through a little bit more of that today from the legal aspect. And I think you'll get some really good information. You know, a lot of people want to avoid the topic of estate planning and completing their lifetime documents. That's never a fun appointment to go to. Sorry. Oh, hey. They say, I don't really want to talk about it. I'll do it later. My heirs can deal with it when I'm dead and gone. Estate planning is for the rich, and I'm not rich. I don't have anything that I need to plan for. A lot of people think it's just wills and trusts, but we're going to find out today it's way more than that. They're concerned about, I had this conversation yesterday, it's so expensive. I can't afford to do that. And for some people, they just don't know where to start. So we're going to talk through a lot of these things today and hopefully give you some information if those are your struggles. Maybe they are, maybe they aren't, but it'll help answer some of those questions today. You know, back in February of 2023, an extremely talented board-certified elder law attorney that I happen to know told me that lifetime documents are more important than your will. She said, these documents take care of you while you are alive. And as she followed that up, she said, what happens after you're dead won't mean nearly as much to you than as when you are alive. So we're going to learn a lot today. I hope you will join me in welcoming Linda Solash-Reed. Be prepared to take some good notes, write down some questions, and let's give a hand to our panelist, Linda Solash-Reed.
Thank you.
Well, Linda, I know a lot of people here in the room know you already. Some of
And
them.
thank you for still being here.
And they've heard you speak before, and they may be thinking, well, I already know what there is to know. But before we dive into that, would you just kind of give a quick overview of who you are and what brought you to this point?
Okay. I have been a member of a bar since 1979. You do the math. I did go through school quickly, but still, the math is still the math. I have had pretty much 3 legal careers. My current phase of my legal career started in 2005, which means I have been doing elder law for 20 years.
Wow.
When I started back in private practice, I was doing estate planning, but a lot of questions were what would be considered elder law. And I thought, you know, I am a boomer. These questions are coming from boomers. You know what kind of a lump we are in the population. So I said, let me take some classes and get into this elder law. Well, as they say, and here we are, the rest is history. I took a lot of classes, eventually taking yet another exam to become board certified by the Florida Bar in elder law. And personally, through the course of these years, of course, neither my husband nor I were native Floridians. We moved down here. We were the only family we had. And then both sets of parents moved down here. So while I was practicing elder law, I was having 4, count them 4,
Wow.
personal elder law experiences. So,
You say that so pleasantly and eloquently.
because I'm on the other side. And trust me, the one thing I can bring to discussions is I know that when you are living it, when you're the one receiving the advice, it feels a whole lot different than when I'm sitting on my side of the desk and telling you, you know, what could happen, what should happen.
Yeah.
When it does happen, it's like, yeah, it's yikes.
We're really glad to have you here today. I think you'll agree we've got a wealth of experience with us. Before we start digging into things, when we always meet with our panelists before we have our seminars because we want to go over some things. So we thought we would start today with story time with Linda. Give us a couple of examples of some situations that went south, that went wrong, poorly planned estates.
Okay. Well, we'll start with what is seemingly a small example. A woman was widowed. As is not uncommon, one spouse did most of the finances and the business, and that was the husband. The husband was an Apple guy and had a Mac computer. He did not share his passwords. If any of you have tried to contact Apple or to try and hack into a Mac product, let me just say that this woman, in addition to all the issues of being alone and widowed, had to deal with just incredibly difficult technical issues, incredibly difficult, that I couldn't help her. I put her in touch with my IT people to see if there are any people in that company who could hack appropriately and get her help. I mean, because really that's what it takes. So share information. Okay, the other 2, I'll try and make them quick because I've got lots of
A few
horror
stories.
Yeah, the one is sometimes people ask me, is it too late? And my smart aleck answer is, if we're here talking, no, it's not too late yet. I was called into a situation too late. I made a house call to a bedridden individual on a Friday, and even though I don't usually have this kind of turnaround time, I had an appointment Monday to go back and have this person sign the documents because they were in home in a hospital bed.
Not good.
Not good. Well, you know the end of the story is Monday wasn't soon enough. This poor person died without any plan in place, without a will, without a trust, with nothing. This person was the youngest of 12 siblings, which meant that I had to look at the statute, go up the family tree, go out the family tree to siblings, and then, because she was the youngest, go down the respective branches. This woman's estate was between $200,000 and $300,000, which was nice but not a huge estate. If I were to show you the stack of paper it took to resolve this, because in her situation, we had to track down great nephews, some of whom were adopted, some of whom gave up parental rights. That probate cost more money than if she had millions of dollars in an investment account and a will. Don't wait. None of us know what our life will shake out to be. So the other one is, it was a hit, but you struck out. You got up to bat, but you struck out anyhow. Somebody thought they would save money and go online and do a will. So they were heading in the right direction. Well, they said, I want to give, this asset to Joe and this asset to Jane. Okay, so then I'm reading the will and say, okay, there's always a clause that says, and everything else goes to somebody called the residue. Well, there was no clause, because they didn't know what they didn't know. They thought if I just wanted to give Joe and Jane what I wanted them to have, all the rest of the stuff, who knows? So they had the worst of both worlds. They had a will that had to be probated, but the statute kicked in to say who would get the residue of their estate, because they really went penny wise and pound foolish.
Yeah.
It would have been a simple will had they come to an attorney at the time, and it would have saved it would have accomplished what they wanted to, more than saving money.
Right.
Okay, so.
Wow. So some of those things are kind of major, but some are kind of minor, and
Right.
it still led to a major.
Right, because again, you don't know what you don't know.
Mm-hmm.
And that's why, I go to a dentist, I go to a doctor, I go to specialists. When I have medical conditions, I don't go online and decide, oh, I can get this over-the-counter remedy for this.
Yeah, for sure.
I want expertise.
Okay. Well, let's take that a step further then, because we hear these two terms used somewhat interchangeably. What is the difference between estate planning law and elder law? And can you do both?
Well, yes, and there is a huge overlap,
Okay.
of course, in estate planning and elder law. I would say estate planning is kind of the core of what I do, and I know we'll talk more about lifetime documents.
Mm-hmm.
The big difference I see is that elder law focuses on family dynamics beyond just who gets what or who does what. In my particular practice, I spend a lot of time talking about long-term care and how to pay for health care costs, because as our financial people from Evershore would agree that the biggest risk to financial stability as we age is unexpected, unplanned medical costs. That's a huge part. And when you deal with estate planning, when you deal with long-term care, when you deal with children who might have needs from birth and might have needs for special planning, you're not looking at just the individual, you're looking at the whole family system, and you're looking at issues beyond the law. I'm not sure I want this broadcast, but someone said elder law is as close in law as you get to social work, as a field, because for better or worse, that's some of what we have to deal with, the family dynamics and the family systems.
Gotcha. Okay. So you're part psychologist, part attorney?
I am an unlicensed psychologist. Well, like my husband says, you're not a doctor, Lynn. So.
Okay. So you referenced, and we talked about it a little bit earlier, lifetime documents. What are they, and how do they differ from end-of-life documents, and why are they so important?
Okay. Well, the first document, and the most important document for most adults, is the durable power of attorney. That is the document that says, my document would say, I, Linda, appoint Beth as my agent to stand in my shoes and do any legal act on my behalf that I could do. It's a very broad power, and it's very important. What kind of legal acts are we talking about? Well, if I'm in the hospital, if I'm, in a car accident on the way to the office, Beth is going to have to file an insurance claim. She's going to have to hire Morgan & Morgan to sue the driver. She's going to have to maybe move money from one account to another to pay bills. She might have to file a disability claim on my behalf. She might have to file a tax return. Any document that requires a signature, you need someone with a power of attorney. The reason this is most important is because in the absence of a power of attorney, there's no default. You can't look at the statute and say, okay, well, Linda didn't do her homework, so we'll look to somebody. There's nothing. What the statute says is if an adult cannot manage their own affairs, cannot make their own decisions, and there's nobody named, you have to get a guardianship in place. I do a lot of guardianships. Frankly, I make a lot of revenue doing guardianships, and pretty much all my gray hair and my clenched stomach comes from doing guardianships because they're ugly, and I really want my clients to avoid them.
Because a guardian is somebody you probably don't even know, right?
Well, it could be a trusted family member who steps in. If you don't have a trusted family member or one who meets the criteria, like no felonies, no abuse history, which we hope you have some friends who don't. Yeah, okay, I'm not glad I know where I'm going there with that one. But the deal is it's court appointed, it's under court supervision, and it's intrusive and it's expensive. Because the guardianship continues until it stops. Either if you're using me in the accident, if I recover 6 months, okay, we can go to court and say, hey, I'm back, the guardianship isn't needed.
But you will have had to have paid that guardian for that 6 months worth of work.
Correct, and it would cost a lawyer to file it. It really is intrusive.
And most lawyers aren't being billed at minimum wage.
No.
Okay.
No, not exactly. So that's why that is important. You need it, and if you don't have it, you're up the creek. The other set of decisions where we want to name people in advance of you meeting them is healthcare. In Florida, we call that person who makes those healthcare decisions on your behalf your healthcare surrogate. Those decisions can include and should include end-of-life decision-making. If the way the statute is worded is, do you want extraordinary measures taken to prolong the dying process? If 2 doctors say there's no reasonable medical expectation that you will recover. We call that document a living will. It is sometimes called an advance directive. Sometimes people get a document called 5 wishes, which is related. Those documents say who you want to make your decisions, and particularly for end of life, what you want those to look like.
I'm sure some people are familiar with the 5 wishes. A lot of the hospice organizations will provide those. Is that considered a legal document?
It can be if it's appropriately signed at the right place. I have some 5 wishes in my office. I don't use it for a healthcare document or living will, but I like it because it allows you to talk about things beyond just the who and the what legally. It allows you to go into really what your final wishes are, what you would like your treatment to look like, whether you like music, whether you want visitors, whether you don't want visitors, that type of thing. It can be used as a legal document, but I'm really practical. at least in the paper copies I have, you have to flip to the back pages to see who makes decisions. When you get a healthcare surrogate from me, it's right on the front
Single
page.
page.
And I like that information where a hospital or an ER or a doctor's office doesn't have to, flip through to the back page to see who they need to call. So I encourage people with the 5 wishes or just through any other way that is available to you to put down your wishes beyond just who and the legal piece.
So that brings to mind a couple of other questions, and I know you've got a couple of other documents to get into, but I'm gonna ask these real quick. Do I need to tell the person I'm nominating that they've been nominated?
Well, there is no legal requirement that you do so. I would strongly urge you to do so. I would urge you to do 2 steps. 1, ask them if they would be willing to serve. And keep in mind that if I would say, yes, of course, Beth, I'll do this, when the time comes, if Beth needs me to step in, I'm not forced to if something changes in my life, which is why we always have 2 people named. But that's, so besides just getting people a heads up that, hey, are you okay if I name you here? For healthcare in particular, you might be, or the person might be called on an emergency basis where a quick answer is required. If Beth didn't tell me and I get a phone call, I'm like, what? She put me down for what? And the other piece of it too is that in order for any healthcare document to be effective, you need to know what the person's wishes would likely be. Because I know how I would like to be treated if certain conditions are where I end up at the end of my life, but they're not the same as what Beth's wishes are. And if I'm going to help Beth by carrying out those wishes, clearly I need to know what are they.
Right.
And so, yeah, it's, I have all the fun conversations.
So that could even be the hardest part of the document, is having the conversation because you really have to identify in yourself
Well, that's
what you want.
true too, is
done.
that not only is it hard to talk about this, and depending on who you name, family members, children, parents, some of them are not comfortable having this type of conversation with each other.
Yeah.
And yeah, but true. One reason why we might not be comfortable having the conversation is it forces us to face our demons. What do we want to happen?
Right.
Not that, we're guaranteed that it would be possible, but just in general, what are those wishes?
So we've got a durable power of attorney, a healthcare surrogate.
A living will, that's the specific plug me in, don't plug me in. And then, even though you heard me rant about how guardianships are evil, we don't want them, we want to avoid them, lawyers do redundant things because we're lawyers. So you also sign, at my office, a pre-need guardian declaration, which says that, just in case somebody files for a guardianship, while I have full capacity to know who I want, I'm going to name these people to serve. So if the worst case happens, there's something on the record about who you want and your wishes.
And other than the fact that these documents apply while you are living,
Yes,
is there anything else that makes them more important than the wills and trusts, the end-of-life documents?
Well, it really is that they affect you on a day-to-day basis, and they also the absence of them can cause your family a lot of issues and a lot of heartache. So
because they're making decisions on assumptions.
Right, and they would appreciate the guidance
Sure.
from you. I know that, well, you know, my daughter is not a good example because she grew up with all this talk, so.
Well, but I will tell you, my husband died 11 years ago, and a month before he died, we had a conversation about what to do with life insurance should anything happen to either one of us.
Okay,
That was such a gift
sure.
because it happened out of the blue, had no idea it was happening, but we had had that conversation.
Right.
And in our late 40s, it seemed meaningless to have a conversation about that.
Right.
Little did I know I would have to, oh, well, we talked about it and we said we would do this, this, and this. And so when family members said, why are you doing that? I'm like,
Mhm.
well, we had a conversation and this is what we decided. It was
Okay,
so easy.
Well, and, yeah, it's tough to have those
Yeah,
kind of
it is. but-
learning experiences, but situations like that are not easy. But having the plan, having the conversation makes it easier.
Mhm.
Take some of the burden away. Nothing is going to ease losing a spouse or a loved one, but at least if you're not fretting about what to do with the
One less
insurance
thing,
proceeds, or, oh, did we make the right decision telling the doctor to do this? Well, if you know that's what I wanted, then
Right.
at least you know that that decision was correct.
Yeah, 100%. Okay, so let's say someone has, they did their estate and lifetime documents in their 50s, and here we are 20, 30 years later. Does anything need to change in those documents?
Oh, probably. I'd say that your minor children are probably over 18 now, but besides that, it's time for a refresh. Look at the who's in your life, who are the best people to do what, who do you want to benefit. And it may be that if you had a will or a trust, that everything is going to the right people and you still have the right people in place. That could happen. I'm not going to say that you absolutely need to redo everything after 20 or 30 years. But it is likely that somebody you named to be your executor or personal representative might have predeceased you. They might have moved away. Things happen. For those lifetime documents, though, if those are more than 10 years old right now, I would say, and trust me, lawyers never say a blanket thing, but if your documents are more than 10 years old, if you came to me with those, I would say, let's just redo them. Current format, they're fresh. You might even name the same people, but you don't want anybody to question that the documents are accurate and still your wishes when it comes time to present them to a third party, whether it's a bank or a hospital. So, you know, there's 10 years, 20, that there's not a specific line. I would talk for years that there was a 2011 change to the power of attorney statute, and now that's quite a number of years ago already. So, I mean, that still means if you have a power of attorney from before 2011, you know, run, don't walk to get it updated. But even those that are 10 years old, you still might want to.
Okay. If I have a trust, can I change the trustee at any time?
Absolutely. When we talk about trusts here,
Mm-hmm.
I'm going to be talking about a revocable living trust, which is typically what is used in estate plans and is usually compared to using a will in estate plans. A will trust, it's a revocable living trust. You can change the terms of that type of trust just like you can change the terms of your will. You know, I'm not intending to be a smart aleck, but as long as you're alive and you have capacity, you can make changes.
Okay. And if I remove someone as a trustee? Do I need to tell them you've been removed as a trustee, or does it depend on my family
Well,
situation?
If they were not serving, if you named them as a successor down the line, then there's probably not a need to tell them. And there are different rules. If I am serving as your co-trustee, well, certainly, if you have the right to remove me, yeah, I need to know. If I'm the first person named in your durable power of attorney, if I know that, and if I have a copy of the power of attorney, and you decide, oh, Linda's gone off her rock, or we need to name somebody else, then you need to notify me. And in this case, the law is logical, not usual, but if I have a power of attorney and I don't know that you changed it, then you can't hold me responsible for still using it.
Okay. What are some common misconceptions people have about needing to have wills and trusts in place, especially when it comes to complicated family situations, maybe blended families?
Okay, blended families are a litigator's dream. And not just because you usually have, divorces in the mix, even when it's just, two people who have lost their spouses remarry. Okay, there are ways to make sure that in a blended family where there are children on both sides of the blend, that both sets of children will inherit from their bio parent. But you need to take the step, and this is a really tough one for me, because I'd see a couple, they'd sit across from me in my conference room, and they've been together 25, 30 years, they have a wonderful relationship, you can tell they're just meant for each other, even if it's the second time around for both of them. And they say, well, I trust her, I trust him. They're going to do the right thing if they survive me. They're going to split it equally between all of the children. Well, I truly believe that the couples who say that to me, that they believe that at that time. But number one, things change, cognitive abilities change, and sometimes it's not the surviving spouse that is making the decisions, but the surviving spouse's children who really never warmed up to the step-parent who died first. So I don't want to say, well, you have to put something in place. It doesn't show a lack of trust in each other, but it just puts some safeguards to make sure that each set of children gets something. So will or trust, you need to do it, you need to have the hard conversation. See, I guess, as I said, I'm just full of hard conversations here.
We use the term, and this wasn't something we really delved into, but we use the term will or trust. How do I know what I need?
Okay. This time, I came somewhat prepared, and out on my table out there, I have a will versus trust chart.
Wow.
Now, ready for the legal disclaimer? It is not intended to be specific legal advice to you as to whether a will or a trust is right for you or all the factors, but it's a cheat sheet to know.
Okay.
So
that'll be kind of our homework. We get to review that later?
absolutely.
Okay.
But in general, a will versus the revocable living trust, they will both accomplish getting your assets where you choose and have that process managed by the people you choose to manage it. It's more how that gets done.
Gotcha. Okay. So, everybody stop and see Linda on your way out. And if you if she's up here answering questions, you can stop at her table. and
Table,
pick-
right, yeah,
pick one of
they're
these
out
up.
there.
Absolutely. Okay. Let's see. Oh, this is a great question. How many of you have lived in Florida your entire life? Okay. Not many, right? So does Florida accept documents that were executed in another state? What if you?
Yeah. I'm not gonna say it depends, because that's my usual answer. I'll say perhaps. Okay, and what that means is, states honor each other's legal documents. If a document is prepared under the laws of Florida, other states should honor it. If they're prepared elsewhere and they're valid under the Ohio laws or the Maryland laws, then yes. Florida will, on its face, allow it to be used. But in real life, there are certain checklists that we have. For wills, the big difference with wills is that we call the people personal representative, it's executor. That doesn't matter. We all know who that is. What does matter is that wills are signed in front of two witnesses, and then the witnesses and the person making the will sign again in front of a notary at the same time. That's what I look for. If you tell me, yeah, I did this will in Ohio 15 years ago, but nothing changed. What I would look for is it signed in the right way? Because let's say you have your Ohio will and it's just signed in front of two witnesses. That is a valid will under Florida law. However, to have it do anything, I've got to find one of the two witnesses and have them sign an affidavit proving that they were there. That's why when we do a will or when I review a will, I look for that second signing in front of a notary. So that means we don't have to go back and find a witness. I am just now struggling to find a witness to a will that was done here in Orlando, and this is not easy. Well, I found one of the witnesses right away because he's dead, so he is not signing any affidavits in front of the clerk.
I hope not.
I hope not too, so I have high hopes for the other one who at least is alive,
But you gotta pin them down.
we have to find them,
Yeah.
first of all, and
Yeah.
so, there's that. More importantly, powers of attorney. If you've helped a friend or family member with their business affairs and tried to use a power of attorney, you know that banks and financial institutions don't like them. If they're not Florida documents, and even if they're valid Ohio documents and you're using them in a Florida branch of a Florida institution, you got problems. I'm not gonna say that certain banks don't cause me a lot of heartburn over perfectly drawn Florida documents, but it's more likely to cause problems if it's an Ohio document, so. We just want to make it as easy as possible for the potential use of these documents. So, yeah, so the validity, is only the first question. Is it valid? But is it the easiest way to accomplish what your goals are, which
Yeah.
is to have your loved ones be able to help?
It can be done, but it would certainly be easier
Right, to
if
have,
it was,
Yeah.
done here. So
yes.
let's take that a step further in looking at like a trustee. So if I have a trustee's in a different state, maybe California, and that's I don't know if that trustee is an heir, are they subject to any taxation or anything there?
Not from our perspective. I can't say if California has an inheritance tax. So perhaps if one of your heirs or beneficiaries lives in a state where they have to pay inheritance tax, there may be tax. But from the estate or gift tax perspective, no.
Okay.
It doesn't matter here, and you can have a trustee in another state
That's,
in Florida. What I do want to mention, though, one thing to look for, going back to the foreign wills, is you do not have to be a Florida resident to be somebody's personal representative if they are a relative or the spouse of a relative. And the list of relatives is really long and air. So if your personal representative is your predeceased spouse, third cousin's wife, that'll probably work.
okay.
But if it's the best friend you've had for life and they live out of state, that's a no-go. So if you
Gotcha.
come to town with the Ohio will, we want to be sure that your personal representative are either family or residents here in Florida.
Okay. So if I don't have family, and we have a lot of people that come to our seminars, and that we work with through the course of our business that don't have any family. They're, the
Yeah.
last of the Mohicans.
Yeah.
How do you go about finding a trustworthy person that can be named in these documents?
It is an issue I work with on a regular basis as well, because oftentimes my clients have outlived everybody they know and love.
Yeah.
Or sometimes they just have shaky family situations where
True.
the
Maybe they don't want their family.
Yeah, their family
Yeah.
is not an acceptable candidate. So I don't have one answer for this. The process I use is, one, I try and expand the pool of people we look at. Some people say, oh, I don't have any family members. Okay, well, do you have good friends? Are there people, is there a friend who right now helps you pay your bills every month? Well, maybe that person might be a good person to be on your durable power of attorney. Do you have a niece or somebody from your church or religious group who's a nurse and who has been generous with their time talking to you about your health care? Might they serve as the healthcare surrogate? So once we expand the pool of who you think about, sometimes you still just end up blank with no ideas.
Mm-hmm.
Then I tap into my pool of professionals. There are people who are care managers who might come from a nursing or a real social work background, who might be helpful as far as healthcare surrogates. And for that role, I want to be a matchmaker. I want you to meet the person, because even though, let's say, somebody I work with, I would trust with making decisions for me, that would only be after I had that difficult conversation telling them what my wishes are. And because I know they click with me, and they might think my wishes are nuts, but they, respect me and my wishes. So I would try and set up a meet and greet and have a discussion, not one that I need to be a part of. And then that might be a way to get health care. For the business side, for the power of attorney, for the executor side, sometimes the professionals do both sides, the health and the paperwork side. Other times you need different individuals.
This is a different nature of the task, right?
Now, some people, I know 2 professional guardians, both are just lovely people, and these are the people who I say, if I need care, these are the folks I want if my family ticks me off. But each of them, one of them only does the healthcare and the medical side, and the other does both, but she's weaning away from doing the medical and just focusing on the finance for her
Yeah.
timing reasons, just what she has going on in her life. So I try and make matches, but you have to, when you face that, you have to be flexible in who you want, and you have to, I would say that, be open to meeting new people. and looking at people in a different way and getting, when I'm gonna say trust me, but trust me, but verify that my recommendations have been good.
Sure.
Because that's what I verified. If I would recommend somebody to be on your power of attorney, I'm staking my license and my reputation that they're gonna take good care of your funds. That they're not gonna join me on my trip to Tahiti with Ruby. And those of you who've been at my office, you know Ruby has got 4 feet and a tail, so that's who I would be running off with.
And you're leaving your husband at home?
To be determined.
Okay, all right. Okay, so I don't have any family members or friends that are going to serve. I've talked to you. You've connected me with a couple of people. I've interviewed them, made my decision. They're not friends or family. I've got to pay them. What are costs looking like on something like that?
Okay, well, unless you need them, cost isn't a factor. Because
Okay.
you
So it's not like you're putting them on retainer,
No,
you're doing the job.
when you need them. Now, as an example, for healthcare, if you land on somebody, you might decide that, well, I want this person to come with me to one visit to my primary care, just so that the connections are made.
And you're gonna pay for their time.
You're gonna pay for their time, their hourly time, and they charge less per hour than attorneys. I just say that quietly.
Okay.
But yes, you pay for their time, they are professional, and one reason we want professionals is because besides the experience, they have insurance and licenses and bonds.
Okay, good.
And that's an important factor too.
Sure, because we see some things on the 6 o'clock news that
Right, and.
are not those people.
Right, and I don't want to see any of the people I recommend on the news.
Okay, all right. Okay, so we've talked about a lot of different things, and I'm sure everyone's taking some things away with them. What are your like top 3 action items that you think in general we should be focused on? So this is where you get your pen out and that note sheet, because you might want to write these down.
Okay, well, we've probably hit on all of these in various
Okay.
ways, but the first one is to have those difficult conversations about healthcare, but also somewhat about money, and particularly where and how to access your finances. Like, where do you have your password for your Mac, where all your finances are managed, things like that. Have that conversation. Sometimes kids and parents, like I said, I get it, they don't want to have that conversation, but do.
Okay.
Take a look at what planning documents you have in place and read them over. Focus on the who. Now, I'm not gonna say don't read the body, the legal powers and authorities and everything. Read those over. But what you need to look at most carefully is who you've named to do what. Are they the right people? Is there a simple correction needed? For healthcare surrogates, I want a current cell phone number with each name. That is one of the rare times I would tell you, if you have a healthcare surrogate, you can write on the original the up-to-date cell phone number, because you want that person to be reachable. Thankfully, with cell phones, most of the numbers are with us forever.
Right.
Figure out if the right people are in place. And here, the last one. Don't be an ostrich here. People come to me and sit across and say, well, if I die, nope. Stop right there. We don't know when, we don't know how, but there's no if about it.
True
Deal
story.
with it.
True story. Awesome.
Okay.
Thank you.
Thank
Did
you.
I know you've got some questions, but did you learn a lot so far? Yeah, this was good stuff. Educational partners, I'm sure we're gonna need some mic runners, because we've got, does anybody have a question? All right, so, oh, Mark has one. Well, you can ask it while you're walking up.
Linda, what's your opinion on copies of documents versus originals? And the second part is having a banking institution as your trustee or power of attorney on legal documents.
Okay, by statute, the lifetime documents are copies, electronic copies, paper copies are as valid as the originals. I'll throw this back to Mark slightly, is if we do recording of original documents using a power of attorney, we might need an original in that limited context, and sometimes, despite what the statute says, banks want an original, but that's because banks don't follow the same Florida statutes that the rest of us have to follow. Little editorial opinion. Okay, you said original versus copy.
And can a bank
Can a
serve
bank
as?
serve?
Having a banking institution serve as a trustee of a trust or a power of attorney.
I've found that as far as powers of attorney, I haven't found an institution in the last number of years that would do that. Financial institutions, banks will serve as successor trustees. Some of them have very high dollar minimums in order to serve. Some of them have higher dollar minimums to get an individual person assigned to your case. I work with professional trustees who are not institutions, who are individuals, who fill that gap for people who might want a professional trustee but don't have 7 figures
Gotcha.
to set aside.
Mark, if you could come up front, Joellen has a question, and then Joanne has a question, so we'll go down the bus here.
I'm your fan today.
Thank you.
Okay.
I have questions. You said that sometimes banks don't like to honor powers of attorney. Is it a good idea to get your
Agent?
agent, okay, on your checking account as a signer?
Okay, excellent.
Did everybody hear that question? Is it a good idea to get your power of attorney as a signer on your checking account? Okay,
If your signer is in town, I would say one approach that works is to go with your power of attorney, go with your person, go to the bank branch and say, this is my person, I want them to sign as the power of attorney. The bank branch will say, we'll send it up to the legal department, get back to you in a week, and we hope that, yes, then the person you bring will be able to sign on your account. To add them as a convenience signer, which means you just allow them to sign checks on the account and not be an owner, that may work, and there's just an article in the law journals about convenience accounts, very little not often understood and not often offered as an option. I do not recommend putting people as joint owners on accounts with the exception of one trustworthy person on one account, your working checking account, where you don't collect a lot of assets, because if I'm on your account as your agent, if Morgan & Morgan sues me and gets a judgment, they're gonna look at your account and say, Linda's on it, I'm gonna collect. You don't want your account open to somebody else's creditors and liabilities.
gotcha. Good point. Joanne?
I am happily single and have an active social life and friends and family and all of that. But a what-if question that I worry about, if something happened to me and an emergency decision needed to be made, how would, say, a hospital or somebody I don't know who I designate?
That is a great,
Do you put a copy of your power of attorney in your wallet?
No, although some people do something like that when they're traveling out of the country in particular. I've heard of people do that. That is a great question, and I'm gonna give that some more thought, but what you might do is make sure that your primary care doctor has a copy of your healthcare surrogate designation in your living will. And I don't know if this works in real life, but in theory, let's say your doctor's in the Advent Health System and you go to an Advent ER, they should be able to find you and see that. Some people have cloud storage possibilities where some people there's some of these entities that have cards that you put in your wallet, doesn't have the document on it,
Yeah.
but says, if you find me on the street, this is my login. So there's that, and I've looked at some of those companies. I haven't really landed on one that I work with, but that's what.
We're actually only allowing people whose name starts with J to ask a question today. So, well, we're going to, you can change it in a minute, Larry. Jeanette is next.
Mine's Jay, it's Jeanette.
I know, that's why I was going to you.
Okay, a couple of things you just said about how you know the power of attorney. When I go to the hospitals, Advent or ORMC, they always ask me, do you have a power of attorney? Do you have this, that, and the other? They want a copy of it.
Yes.
So when you give it to them, we're just going for your tooth or your foot, they want it, so they'll have it. My question was, you kept talking about 5 wishes. What were the wishes, the 5?
Oh, the book, Five Wishes.
The book, 5 Wishes, that is a pamphlet to fill out, and it's about your wishes for end-of-life care. About, not necessarily the legal side of things, but, I always use this example, so forgive me that you've heard it before. My wish would be that my dog gets to cuddle in bed with me, because Ruby, my dog, sleeps with us, and my husband, granted, I don't kick him out. But, that would be, if I'm at the end of life, that's what I would want. So I wouldn't put that in a legal document, but I would put that in the 5 wishes. There might be, I'm really much of a quiet person, so I would say no background music, please. Things
But
like,
I might say, I want some background
right, but you
music.
might say, and you might, or I might specify that just keep playing Amazing Grace on loop for me, depending on my mood. Those type of things that aren't, specific legal or medical,
Okay.
but more caring.
John in the back row there? Larry?
Just to follow up on your previous response about going to the hospital and having all this stuff, one of the things that I did with my parents, since I did not live in the same town that they lived, is I made each one a notebook of their medical information. I had all their medical history in, insurance cards, POA, living will, and so forth.
Yeah.
And it sat right by the door. Their caregivers knew exactly where their notebooks were. They had to go to the hospital or
Yeah.
whatever.
We call that a go
It
book.
worked out pretty well.
Yeah,
Yeah.
that's good,
Those are
great
great.
idea.
Mark, I think Frank up here in the, okay, we're coming to you, Frank.
He doesn't start with a J.
We've moved on, Jeanette, we've moved on.
My last name is Jameson, my middle
That
name,
works.
my middle name is Jimmy.
Okay. 2 J's, all right.
This is a very simple and easy one, it's not as complex as all the other ones that I've heard so far. And that's why I have a question. My wife and I are in our mid-80s and we're pretty decent health, we travel, etc. Our daughter and her husband, who are in their early to mid-50s, both employed well, both very smart, etc. They're about 5 miles down the street from us, and that's our family. So it would seem to me from our discussions, we need to address these issues, but thinking out loud on this, the fact of living wills or powers of attorney, etc. and so forth, would be absolutely disgusting. It's so simple for us compared to a lot of people, thank God for that. that we were able to do that, that it's, if I drop dead or whatever, she gets it as the wife, and she goes, then the daughter gets it, and she goes, the husband gets it, so, and of course you have combinations and permutations, depends on who goes first and blah, blah, and all that sort of good stuff. And we have our finances and stuff, we're down to 2 or 3 banks, and, I can list every dang thing on a page out of the computer that shows where everything is, and it's very simple. The simplicity of it all is just, I haven't worried about much of this stuff because it's so simple, relatively speaking. So other than the nuances and like what the current requirements are in the state of Florida vis-a-vis what they were 20 years ago and other subtler nuances to the thing, is there anything that makes this more complex from our perspective that just jumps up and bites you or should bite me or whatever? Because it seems like we've got about as simple arrangement as you can possibly have.
Right. So, can you make it harder?
Can I make it harder for you?
Well, that's what I'm looking for.
I don't want to make it harder.
I don't-
Sometimes
Yeah.
that's all it takes. It doesn't have to be complicated. People's lives are sometimes. But don't look for problems. I don't make things
Yeah.
complicated.
Yeah.
I'm happy when somebody comes in, such as yourselves, where you know what you want, you know the people, you have everything honed down. When you say you have a few accounts, oh my gosh, I had a lady come in yesterday who's dealing with both of her parents' estates. They kind of died close to each other in time. And her father, despite what their financial advisor said, he's got CDs all over the place. And so this poor woman is trying to get a handle on that, and she's not going to be able to wrap this up for years, maybe not years, but it's going to take a while because of accounts here and there and CDs and whatever. It's
Gotcha.
like, just keep everything in a couple of financial
Well,
institutions.
we've got your phone number on your card, and
That's right.
and when we call you, come to see you, I would expect from my discussion, your discussion, we're not gonna give you a whole hell of a lot. Hopefully, you'll give us what we really need, and that's fine.
So,
Okay.
I'm sure she will. All right, so let's do one more question, and then if any of you have remaining questions, Linda's gonna stick around for a few minutes to ask. I think this lady has a mic.
Yes.
Oh, this is our new person. Thank you for
want to
coming.
refresh your documents, and one person is not able to sign anymore. What do you do in that case?
That is not a problem at all. Well, not for us as far as executing documents. It's either the person, I mean, if they can make a mark of any sort, it's witnessed and done in front of a notary, so it doesn't have to really look like a signature. If somebody really doesn't have mobility or is paralyzed on their dominant side or whatever, the statute says that they can direct a notary to sign on their behalf. So as long as we know in advance, because the document needs to look a little different to say that the person asked the notary to sign on their behalf, once we know that, it's not a problem. I've had people who weren't able to express themselves, who had aphasia or something, couldn't speak, but as long as they can communicate in other methods, we make it work.
What if they're
Oh, cognitive impairment, how does
Well,
that?
that's, cognitive impairment is not an on-off, it's more of a range, and certainly there are people who have cognitive impairment to the extent they don't have a lucid moment. Lucid moment is a legal term, and like the Supreme Court says about pornography, I know it when I see it. Or, honestly, I pray that I know it when I see it, because it can be tough. But you don't have to be lucid if you have a diagnosis of cognitive impairment. That doesn't say you can't plan. As long as you have a lucid moment where you can communicate with me in some manner, then you may be able to go ahead with the plan.
So that's very case-by-case dependent.
Absolutely, and sometimes day-by-day dependent.
Awesome, awesome. Well, I know that many of you took some great notes. I certainly did. And I know that Nicole did, because she's going to draft all those notes and send them out to you, so you'll have her notes as well. Did we try and sell you anything? Okay, all right. Just remember, we want to know what you're going to do with that information that you got today. So taking action is super, super important. You are our connection to the world. Your feedback to us matters, and that's why we want to make sure that we take care of snatching those blue sheets from you. We want you to take the time to fill those out. I totally forgot to introduce Nicole up front, and Andre, who helps with setup, and Susan, who's out front, and Greg, who's in the back with photography. You can hand your blue sheet to any one of them, and we would really appreciate that. Next month, oh my goodness, we're diving into money. So financial issues, Sean and Dana from Evershore Financial, we're going to be talking through how to make the money last and pay for all the things that we need. So you'll want to be here. You can go ahead and pre-register on that blue sheet if you would like to. And we will be here next month on February 19th, 10 a.m. Bring a friend so you can get, that has never attended a seminar before, so you can get in on the drawing. We'll hope to pass out a few raffle tickets. We'll be giving away another $50 gift card. We do always like to, oh, this is a good one, end with a quote. I like this one. Prepare for everything and be prepared for anything. I think we learned a little bit about that today with Linda. Let's give her a round of applause, and we thank you all for coming.